The Supreme Court says it will hear a case from Mississippi challenging Roe versus Wade. The case will give the court's conservative majority its first opportunity to weigh in on state laws restricting abortion. Joining us to help break down what this means and how it may or may not impact South Carolinians is David Hoffman, founder of Hoffman Law Firm. Good to see you this week.
Good to see you as well. Thank you.
It's a very sensitive topic, an extremely controversial topic in many households in many parts of the country. First, if you could set the stage for us and just remind us what Roe versus Wade is all about.
Gladly. And you're right. This is a very controversial topic, and I am only here to break down the law and kind of just describe what's going on legally with Mississippi and South Carolina. But it starts with in the 70s, the case of Roe versus Wade. Everyone's heard of that. What Roe versus Wade said, the controversial part is it alluded to a constitutional right to have an abortion. That part is a little bit iffy, but the gist of Roe versus Wade is that they defined a line in the term of a pregnancy as viability. Before viability, a fetus could not live outside of the mother's womb. After viability, a fetus could survive outside of a mother's womb. And this is at about the 24-week mark. So what Roe versus Wade said is that a woman has a right to choose an abortion up until the 24-week, or give or take. It's a medical determination whether or not a fetus is viable, but it's around the 24-week mark. So you have the right to choose up until then. Anything beyond viability, there have to be extreme circumstances. So there is nothing in any Supreme Court decision or in any state law or anywhere that allows a person unfettered access to an abortion. The term that politicians use is late term. That's actually not a medical term, but there's nothing in any law, there's nothing in Roe versus Wade that allows an abortion for convenience or anything of that matter late in the term, close to the delivery date. No state allows it. Roe versus Wade doesn't allow it.
Okay, and I want to get into late term because that is something that we've been hearing a lot about in recent months and within the last couple of years. A very, again, highly controversial idea.
It's an inflammatory phrase.
Okay, so we'll get into that in a minute, but I want to get back to the Mississippi case and exactly what they're challenging. So this is Dobbs versus Jackson Women's Health Organization. So
that's right.
So tell us more about this particular case and what it is that they're challenging.
So remember we talked about viability at about the 24-week mark. What this case in Mississippi is purporting to do, what they're trying to do, is they're trying to move the date to 15 weeks. It's not a viability date because viability is a medical decision. 15 weeks would be a legislative decision that says anything after 15 weeks, you're not entitled to an abortion. Now, the interesting thing with that is medically, there really isn't a whole lot of difference between 15 weeks and 24 weeks. The cerebral cortex of a fetus, with pain sensors and understanding and any of the components that we think of as human beings, those are not developed yet. Around the 30.
Oh, no, I'm sorry. Just briefly, if I could just ask you this one question. So South Carolina's law right now, so if Mississippi is pushing for 15, what is South Carolina?
South Carolina is pushing for 8.
Okay.
8 weeks. They call it the fetal heartbeat legislation. That sounds very, very, very sympathetic and very, we love people, but the fetal heartbeat that's not the same as a pain sensor. That's not the same as medically, that's not all that significant based on the research that I've done. What is significant is the development of the brain, development of the cerebral cortex, the region of the brain that starts to develop rational thought. And that's usually not until week 30 or later. So it brings up an interesting question for me. Is if what you really want to do is overturn Roe versus Wade and make getting abortions more restrictive, you're not really doing much by changing viability at 24 to 15 to 8 to 2. It's almost like, when you have solicitors running for office saying that they're going to, they're going to have a lot more DUI prosecutions, but really they're not changing anything. All they're really doing is changing it from 0.08 to 0.07 so that they're not taking more drunks off the road. They're just redefining what you call an intoxicated person by making it stricter.
Mm-hmm. So when we're talking about abortion, either you're
for or against it,
or you support it.
Pick, because excuse me, each statute, each state that's passing these things, they're still allowing abortions. Mm-hmm. They're allowing them. They're still happening.
Right.
So it's just a matter of. It's just become so divisive politically. It's so divisive politically that who really knows?
And what I want to do is when we come back is to get into just a little bit the late term notion so that people can better understand exactly what we're talking about when we hear that jargon being thrown around when we're listening to news and reading information. So we're going to do that after the break. Don't go anywhere. Welcome back. We've been chatting with David Hoffman, our legal analyst here, breaking down a case that is going to be heard by the Supreme Court for the first time in a while, especially with these particular sitting justices on a case brought forth in Mississippi. And so we're talking about abortions, the right to an abortion, and what that means from state to state. And so in Mississippi, the challenge is to determine whether an abortion can take place before or after the 15-week mark. And what you've just been telling us is that there really is no difference between 2, 8, 15, 24 weeks. So we're talking about the viability of life. But we've been hearing this term about late term abortion, when you're thinking 9 months down the road, babies are being aborted. Now, there are some circumstances in which this is happening. Maybe you can dispel some of the myths surrounding what the reality actually is.
It is a political stunt. And unfortunately, there's no other way of putting that. First of all, the term late-term abortion, it's not a medically recognized term. First of all, there's no Roe versus Wade, no state statute, no state law, no court anywhere has said that you can get an abortion towards your birthday for convenience, because you forgot, because you couldn't get around to it, because you couldn't save up enough money in time. No court, no ruling, the Supreme Court, nobody makes that legal. What has happened is for example, a fetal abnormality where the baby could not live, he could not sustain life in the mother's womb or outside of the mother's womb. It's a tragic scenario where a specialist will induce labor, and then the care becomes palliative for the newborn infant who's not going to make it anyway. That's when an abortion is done to save the life of a mother, things like that. It is a tragic, horrible scenario, and it's being wildly politicized by talking about, these babies are being ripped from their mother's womb. And no, I could not imagine being a mother where that has happened, where I've had to endure that, and then hearing a politician speak about that horrible, horrible event as callously as that. That is not what's being done, and there's no court in the land that makes that legal. Right now, there's no court. Roe versus Wade doesn't make that legal. There is no unfettered right to an abortion in the United States. Okay. So that's what brings me back to what really is the political motivation for just moving the goalposts a little bit. You can at 15 weeks, but you can't at 24, when the development of the baby really hasn't changed all that much. Now, there is one interesting thing that South Carolina is one of, I think, a handful of states that believe the pain sensor model, the pain sensor approach. And so we've tried to set it early on, and medically, there is no such thing as a pain sensor where we've set it. It just all seems like it becomes political when really what we're talking about is something very, very medical. It's a medical decision, that has become very politicized.
And I don't want you to have to whip out your crystal ball, but what do you think? Where do you think this is going to go in the Supreme Court?
That's a really good question, because this is one of those where I've got maybe three theories. I think, one, the Supreme Court could come along and say, look, Roe v. Wade was well thought out. That viability date with the right evidence from the medical establishment, a viability date for a particular pregnancy can be set. It's good law. There's nothing that's changed that has, that changes that, and they may stick to precedent. Or they may come along and say, look, the word abortion doesn't appear in the Constitution. A state's right to pass legislation governing its own rules on who may have an abortion at what time, that's up to the states. This is not a federal issue. They could go that route, and then there could be a kind of another approach where they just say, okay, we're moving viability up to 15 weeks because this is the case in front of us. But keep in mind, South Carolina's got one that's coming up there that puts it at 8 weeks. So I don't think they're going to go with the third option. I don't see how they could. They're going to, if they're going to rule on it federally, then Mississippi's 15 weeks versus South Carolina's 8 weeks. How do you rule on that federally? I think they've got one of two choices. They either need to go with precedent, or they need to just say, look, this isn't a court. This isn't a federal issue. States can set what they want.
Well, we'll see how this plays out. David, as always, thank you so much for your input and your insight.
Well, thank you for having me.
We're back after this.